All right, so what I wanted to do was I have a list of questions here, and so let me go through those. There are a number of them, about 10 or so. So I'll go through those questions, and then we can open it up and take questions from everyone. So the first one is, please explain what the completed narrative consists of. I have submitted a brief summary of what we went through, but now I wonder if I should go into all the terrifying details of our evacuation and the horrible aftermath that still affects us. The answer to that is yes. We do need to know the details of the evacuation and of the aftermath. So if, for example, you were someone who was trapped as a result of the fire, if you woke up with your house on fire, whatever your specific circumstances are, we need to know that. So that is important. And then the other very important issue for the non-economic damages involves what your life was like after the fire. In other words, how did your life change as a result of the fire? So that's something that we really would like to know. And if you can describe that for us, it would be very helpful. So that's the answer to that. Now, next question. Because our new build will cost substantially more than the home we had prior to the Camp Fire, can the increased homeowners insurance be included in economic losses? If I understand correctly, you're asking whether or not the increased price of insurance that you have to buy for your new home can be included as an economic loss. If so, the answer to that question is yes. That is something that you can recover. So if you, for example, were paying a premium of $1,300 a year, and then post fire you had to pay a premium of $2,000 a year, then you can include that. Typically, we include it for 3 years, but if there's a reason why you think it should be 5 or some other, just let us know and we can include that. Okay, question 3. Can you give us an example amount and outline exactly how much the lawyers will get and how much we will get? Okay, so the example here, it says 300,000. So if the final award with everything, attorney fees, economic, non-economic, was 300,000, then the attorney fees on that would be 100,000, and as the client, you would receive 200,000 minus whatever your costs were. So if you did not have substantial costs, if, for example, your only losses were personal property or non-economic damages, something that you didn't need an expert for, then you'll pretty much get the entire 200,000. There will be some joint costs that are going to be very minor, but not very much. Typically, it's about 1%. On the other hand, if you needed a rebuild estimate, an erosion estimate, an arborist, those are usually between 1,000 and 2,000 each. So that would be another 5,000 or so, and that would be taken off. But that's pretty much how it would work. There's a sub question here and says, what about 35,000 in FEMA monies and 10,000 received from the wildfire assistance program? You will not have to pay any attorney fees on that, although they likely will be deducted from the 300,000. So let's say you had 10,000 that you received from the WAP, the Wildfire Assistance Program. The final award would be 300,000 minus 10,000, so it would be 290,000. And the fee would be 1/3 of that 290,000. For the FEMA, it's really unclear. Again, technically, the trust does have a right to deduct it. What's not clear is how they're going to get the information. We had our first meeting of the Trust Oversight Committee yesterday morning, and we didn't get into details like that, but it wasn't at all clear whether or not the trust is going to have access to what was paid by FEMA. So our position on FEMA is, because the FEMA did make a claim, if there is going to be something that can be, in other words, double recovery, if FEMA paid you for something and then you're asking the trust to pay you, then you can get compensated, or then it will be deducted. But if it's for different things, then obviously it's not. So that's the way we have to phrase it. If you did recover FEMA monies, let us know, and we can figure out the most advantageous way to list it. Another question is there going to be a separate award for emotional distress and for economic loss? The answer generally is no. I don't know for sure because the claims resolution process has not been completed, but certainly the way that it's almost always done is there is one award that is issued. So that's my guess as to how they're going to do it. But if they do break it down, then we can see what that means and go from there. Number 4, will we get a letter explaining percentages of economic and emotional distress? If you're talking about from the award, the answer generally is no. Typically, it's done in one lump sum. There are a lot of reasons for that. One of them has to do with tax consequences. Typically, most individuals want it in a lump sum, and then they can assign what happens. In other words, they can say, in my best estimate, in working with their tax preparer, of course, I believe I received X for economic, X for non-economic. That usually is the way that it's always been done, and I think that's the way it's going to be done here, but we'll have to see. Again, it's up to the trustee. Okay, please clarify how fluctuations in the share price of PG&E Corporation will affect us as individuals. For simplicity, if the share price is $10 when the trust is funded, how are we affected if the price decreases to $8 a share? Well, if that happens, then obviously the trust will be worth less than what we had hoped. So when it was funded, it was at roughly $9.15 a share. In order to get to the $6.75 billion, it has to go to $14 a share. Our hope is obviously that it's going to get into the high teens, maybe the low 20s. That would be certainly fantastic. I think that maybe is a stretch, but even if we could get to 15, 16, 17, it's an extra $1 billion, and that would obviously really help. As we've talked about, it's very unlikely that there's going to be anything left in the trust. The trustee views his job as giving all of this to the fire victims. I believe he will do that. So whether there's 11 billion in the trust or whether there's 17 billion in the trust, I think it's all going to go to the victims. So obviously we want that to be as much as it possibly can. Here's a question. I thought the fire fund was 13.5 billion. According to the newspaper article, it is 12.1 billion, 5.4 billion in cash, and 6.75 billion in stock. The reason for that is the initial payment is 5.4 billion in cash. It's technically 5.385 because 15 million was paid 2 months ago in order to get the trust up and running. What's happening with the other 1.35 billion is it's being paid in 2 installments. 750 million in January of 2021 and another 600 million in January of 2022. So that's how you get to the 6.75 for each. Next question is, do the lawyers carve out any amount of the trust for themselves? The answer to that is no. The lawyers are paid when the clients are paid. So when one of you is paid and you receive your check, then we are paid our contingency fee, but we are not, there's no portion of the trust that's set aside for the attorneys. We don't get paid before the clients, anything like that. Next question is, how many claimants are there in total? There are roughly 77,000 non-duplicative claimants. There were, I think, about 85,000 who filed claims, but there were a ton of duplicates. There were at least 8,000. We think it's probably going to be closer to 10. So we're saying 77,000, but it could be a few less than that. The key is the properties. There are roughly 24,000 properties. And so that kind of gives you an idea, because when we typically do cases, we do them by property. So a family of 4, there would be 4 people that filed, but it would be one property. And typically, cases are worth on average about 500,000. This is net of insurance. So, you know, if your place is 1.5 million, you received $1 million from insurance, then it's going to be 500,000 is the value of your case. Here, it works out with the 24,000 to about 560,000 per case. So that's in line with prior settlements. For example, Butte was a little bit lower. The Butte fire in 2015, it was about 250,000 per case. I think this one's going to be higher for 2 reasons. One, there are in some areas a lot of underinsured people, and so that's going to drive it up a little bit. And the emotional distress on average was worse in these fires than it was in Butte because of the number of people in the Camp Fire, in Tubbs, and in a couple of the others, specifically the Redwood Valley and the Lake Fire, the Sulphur Fire, that were trapped. And so you had a higher percentage of serious emotional distress claims. And then finally, the wrongful deaths. There was nothing like that in Butte. There were 3 wrongful deaths. Here, there are probably going to be about 175. There's 130 official, but there's a significant number of people who died shortly after the fire of related causes, whether it was respiratory, heart attack, things like that, that were not included in the official designations. So the last question has to do with why is it taking so long now that the funding has happened for people to get paid? And the answer is that it takes a long time to set these processes up. This is not something that existed beforehand. It's really not something that's ever been done. And so we literally are creating it from scratch. And I can assure you, everybody wants to get all of you paid as quickly as possible. On the call yesterday, that was the main thing the trustee talked about. It's obviously very important to all of us. I mean, as lawyers, we only get paid when you get paid. And I'm certainly not, you know, equating what we've gone through with what you've gone through. You know, you've gone through hell, and it's certainly been our privilege to represent you. But you know, we have been working without having been paid for several years, and during that time, we've shelled out. I can only speak for our firm, but you know, close to $15 million, and when all the fires are put together. So clearly, it's in our interest to get paid as well. We want to get you paid. That's how we get paid. The trustee wants to do it. Everyone wants to do it. So the earliest we can get this done, the better. Again, July 29th is the date when they're going to start accepting claims. It's going to take a while to process them because, again, this system is just set up. It's starting from scratch. It's going to take a while to make sure that we have it right. And as much as everyone wants to get paid, in my view, and I think in most people's view, it's more important that it be done right, because what we don't want, particularly with a limited fund, is to have mistakes in payments that are made. Either way, I mean, we certainly wouldn't want someone at the beginning to get overpaid, and you know that mean that there's less for everybody else. We want to make sure that we're doing this right, that the system works, that everything is being evaluated in a proper way. And remember, this is different than any other type of case we've done in the past, because in the past, you had the plaintiff and the defendant. So it wasn't like we just went to the trustee and said, this is what we'd like. We had, for example, in the Butte fire, we had Quinn Emanuel, which is a very prominent LA litigation firm, on the other side, and they fought us tooth and nail over every settlement. And so as a result of that, you know, you go back and forth and you get a number that's fair. Here, you don't have that. You have the trustee who wants to pay you as much money as he can, but at the same time has to be cognizant of the fact that he has a limited fund, and he can't just say, okay, Plaintiff Smith, you've asked for $2 million, I'm going to give you that $2 million. They've got to devise a system that is fair to the plaintiffs, that gets this done as quickly as possible, but at the same time checks to make sure that all the payments are legitimate. And so that's what's taking so long, and I know you want to get paid. We want you to get paid, but that's the process, and that's why it's taking some time. So those are all of the questions that I have. Chewy, do you have any that have been sent in remotely?
No, Jerry, I don't have any in the chat or via email.
Okay. Well, why don't we open it up then? And who has questions?
Gerald, question. Paul Tiffany
Sure.
here. Um, I understand that if one sells the property prior to the payout, you are diminished in what you get. What happens if you get the first part of the payment? Because I understand we will not get 100%, and you sell after that, but before you get the full amount.
That wouldn't have any impact, because what's going to happen is that the trustee is going to come up with a final claim number. And obviously you'll be a part of that. It's only a final claim when you agree to it. But once that final claim number is made and it's been agreed to by the trustee and by you, it's set in stone. So no matter what happens after that final claim has been ascertained, you're going to get that amount, with the exception of if there's not enough money to pay everyone 100 cents on the dollar, then it'll be prorated. For example, if everyone gets 95 cents on the dollar, but it won't be reduced based upon a subsequent sale of your property.
Got it. Thank you.
Sure.
I have a question.
Sure.
So I was renting through a renter and I didn't have like any renter's insurance. So is that gonna, so they're gonna, like the trustee or whoever is gonna take that into account? Like obviously I wouldn't be getting as much as like the next family over who had a house and blah, 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 all that.
Right. Everybody gets what the value of their loss is. So for example, you don't have real property loss because you were a renter, but at the same time, your next door neighbor may have complete coverage for their personal property loss. So, you know, they may have 250,000 in personal property, and that might cover them completely. On the other hand, you might have 100,000 in personal property, but because you were uninsured, you're going to receive that 100,000, whereas they would get nothing for the same category because they were fully compensated by insurance.
Oh, okay. That makes sense. And we already, like, though you said they're accepting claims on the 29th, like, so we already gave you everything that we needed to. We don't need to fill out any like more paperwork or anything like that.
No, that's something that we do. So what we're waiting on now is to have the questionnaire, which is a formal document that we have to fill out, and then we attach all the exhibits to it. That is going to be completed. Hopefully it'll be completed by next week. That was the goal that we set in our meeting yesterday. If we can get that, then we can get all the bugs ironed out. It'll be ready to go on the 29th, and then we can start submitting.
Okay. And sorry, last question. So you were saying that it'd be good to like get a description of us trying to get out of the fire and whatnot. So like, should we could still add that to like our claim? We can like email you like something like that and add that to our claim.
Yeah, absolutely. You can email it. You can, dictate it into your phone and send that. You can have a conversation with one of our people and they can take it down. Whatever's the easiest. We want to use technology to make this as easy as possible for everyone, particularly because of the requirements for social distancing. So just let us know what works. But yes, I would encourage you to get that to us as soon as possible, because we can't submit your documents until we get that. That's the final piece of the puzzle.
Okay. Thank you so much.
Sure. All right. Who's next?
I guess it would be me.
Okay.
I have a question regarding the letter we just received from you regarding the contents of our home and the value of that. We were insured for $230,000, and of course, he only paid out 75%. We have to make an itemized list, as what you wanted anyway, but it's devastating to try to replace 50 years of items in a year and a half. It's just not done. And then in addition to that, they're going to depreciate it. How can we get the full value of what we should be insured for?
Well, there's two issues there. Number one, once you get your list done, then you want to submit it to your insurance. And most times there are so many items on the list that even when they depreciate it to give you the actual cash value, it's still going to be above the limit, which in your case is 230,000. What we typically face is people will have a list that will be 100 to about 250 above what their contents coverage is. So if that happens, then that's what we'll do. We'll go ahead and you can get the full amount from your insurance, the 230, and then if there's 50, 75, 100 on top of that, that you still need to be compensated, then we get that from the trust.
Oh, okay. So I guess my struggle is that after a year and a half and being relocated, first of all, it's, as everybody here in this meeting knows, it's devastating to try to sit down and list every little single thing that you have. So that's been a struggle. But in addition to that, we're not even going to be able to replace most of this stuff right away. It might be a year or 2 years down the road before we replace it. And they're telling us we have to replace everything. So how does our claim compensate us for that?
Okay, so do you have replacement coverage? Is that what's happening with your insurance?
We do have replacement coverage,
Okay.
but they say we have to replace it all, and then they say they're going to depreciate it. So,
Right. So that's a little bit complicated. What I think we should do is have you talk to Joel Alba, who's our insurance expert, and he can kind of walk you through what you need to do in order to recover.
Alba, A-L-B-A, Joe, got it.
Yeah.
Okay, I have another question, unless somebody else
Sure.
wants to get in here before me. Okay, not. All right. There's no place to live up in Paradise, as everybody here probably knows. If you found a place, bless you, I'm happy for you, but we didn't. And so we moved down to Phoenix because we have support group down here with us, and we did buy a house because we were living in a crappy little rental. Now we want to rebuild in Paradise, and we've told our insurance company that. How does that work into the claim? Because we've already been, we have been paid out a little bit, so.
What you can do is there's nothing about buying another house that prevents you from being able to rebuild and recovering the cost of repair, which is preferable over DIV. So all you need to do is you're going to have to state that you have an actual intent to rebuild, but as long as you say that, then there's no problem.
Okay, well, we've already done that, so I guess there's no problem. I'll thank you for your answers to that. I appreciate it.
Sure thing. All right, who's next?
All right, Jerry, I have a few questions submitted through the chat just now.
Okay, go ahead.
First one, if I have no insurance on my house and I'm going to rebuild, will you take 1/3 of the cost to rebuild?
Yeah. So again, what happens there in those cases, and we talked a lot about it this last time, is that for the economic losses, the fees are supposed to be paid by the defendant. So in past cases, what we've done is the fee has been the fee calculation has been 50% of what the economic loss was, and that way the plaintiff was left with 100% of what their economic losses were. So those were the fees that were awarded on top of that. That's what we're pushing for here, but we don't know exactly what percentage is going to be awarded. The simple answer to the question is, whatever is awarded, the total amount, the fee is 1/3 of that. In terms of what portion of the fee the defense, or in this case, the trust, has to pay, that is going to be up to the trustee, and hopefully it'll be spelled out in the claims resolution procedures.
Thanks, Jerry. There was one just submitted, a follow-up to that. It says,
Okay.
Has the compensation method changed over time? I thought that I would receive X and the firm would receive Y in addition to that amount, so that what we received was our full amount.
Right. No, it's been the same throughout. It's always been a third of the total amount. The confusion comes in based upon the fact that in these suits, the defense has to pay the reasonable attorney fees on the economic damages. And so again, we've always done it as I just described, so that that's exactly what happened. This is a little bit different because it's a trust and we don't have the same leverage that we have in negotiating with the defense. So they definitely will pay some portion of the economic damages fee. We hope it's 100%. That's what we're pushing for, but we won't know until we get the claims resolution procedures.
Thanks, Jerry. Um, During the claim process, will we need to attend any negotiation meetings in person, if allowed?
No, you definitely won't have to. In what'll happen initially is once you submit your documents, then you'll get an offer back. And if that's acceptable or if it's close, then we probably won't have to do anything. We can get it resolved. In the event that it's not, and there are significant issues, then we'll have a mediation. And I would encourage you to attend that either in person or via Zoom if we're still having issues with COVID and social distancing. But the answer to the question of do you have to attend it, the answer is generally no. I think the only thing you'd have to attend would be an arbitration, and that's because your testimony would probably be needed.
Thank you. Has the judge or team designated several, quote, tranches for emotional damages so that the payment amount is predefined? In other words, are people's situations allotted into one of those tranches, and then we are paid accordingly by that particular tranche that we fall into?
They haven't done that yet. Whether or not they do, I don't know. I think what they're going to do is probably have a minimum. In other words, if you were placed in fear for your life, then there's going to be a minimum payment for each individual. And it might be 5,000, 10,000, 20,000. I don't know. They're going to do that. And then they'll probably also have a minimum for if your home was burned down and you lost all your personal possessions, there'll be some minimum. And then they'll look at the unique factors and add on to there. That's my suspicion as to how they will do it. That's certainly what we've recommended. But again, we won't know until we get the claims resolution procedures.
Okay, Jerry, a few more questions are being submitted here on the chat. I
Sure.
believe my insurance company has paid all they are going to pay unless I were to actually start an actual rebuild. If I were to actually start physically rebuilding, I might get more money, more from my insurance company. How would that affect my claim?
It won't affect it at all because remember, what the trust is going to look at is what your total policy limits are. So if you have more money available, but you don't use it, then the trust is going to require you to show that you made a reasonable effort to obtain it. Otherwise, they're going to count it against the total amount you receive.
Is there a range for non-economic payments from what is considered minimally impacted to terribly impacted and in between?
Not yet. I think they probably will have something set up where there's some minimal amount, some floor that no one goes below. But thus far, they haven't done that.
Okay, there's been a couple of questions about the attorney fee issue and clarification on that. It says, so to clarify, the payment of attorney fees by the trust will be determined prior to the submission of any claims when the claims process is finalized. And then the second part to that, it says, is there any upside potential on the second payment if the PG&E stock price goes up?
Okay, so let's start with number one. Yeah, the way that it's going to work is that the attorney fee is going to be added to the portion they have to pay is going to be added to the award. So if the award otherwise would have been, whatever it was, 200,000, and they determined that the economic portion of that was 100, and so they added 50 on for attorney fees, then the total amount would be 250. So all that is added in there. The attorney fee is a third of whatever's received. So if, using that example, the award was 250, but only 75% was paid out in the initial payment, then the attorney fee is going to be a third of that 75% that's paid out. It's not a third of the total. Going to the next part of that, if the stock goes up, could you receive more? The answer is yes. And the reason for that is punitive damages. So one of the things that we did was we had the trust subordinate punitive damages to compensatory damages. The idea being that we wanted to make sure everyone was made whole before anyone was paid punitive damages. However, if there is money left over, then I believe what the trustee is going to do is distribute that out on a pro rata basis based upon the punitive damages aspect. That's my understanding of what he's going to do. So to answer your question, yes, if we get lucky and the stock goes through the roof and it's at 20 and there's an extra several $1 billion, then I think that will be paid out in punitive damages.
Okay, a couple more questions about attorney fees.
Okay.
It says previous town hall, there was an example used, I believe, of $1 million. And it says, are you expecting to get fees on top of fees? Using the example from the previous town hall, 33% fee was being paid by the court. So and again, the numbers I'm not sure are on, but I'm just reading what's here. So the 900,000 plus the 300,000, if attorney fees then becomes 400,000 on 1.2 million, or nearly 45%, not 33%.
So again, the fees are 1/3 of the total amount that's awarded. So I think that's where the discrepancy comes in here. And this is what we talked about last time. The fees are calculated on the total amount. So you add up everything that is awarded, economic, non-economic, and the attorney fees that they have to pay. You get all of that together and it comes out to something. And whatever that amount is, 1/3 of that is the attorney fee.
Thank you, Jerry. Another question here via chat. It says, I had a house at Journey's End. It survived the fire, but they bulldozed it 3 weeks ago. We were not insured. Will we receive full compensation for replacement of our home at today's price?
If an individual owned the home and it was condemned because of the fire and then later bulldozed, then yes, they would. If they were a renter and Journey's End had both renters and owners, then obviously they would not receive the value of the coach or the mobile home because the property owner would. So the answer is it depends. But if you owned a home, and this is not only true of Journey's End, for example, in the 2013 Powerhouse fire, I had a very unusual case where an individual's home was completely untouched by the fire, but the erosion, he lived on a hillside, the erosion was so severe that about 1.5 years after the fire, it completely destroyed his house. The county came and red tagged it and it had to be destroyed. So he was entitled to have his house rebuilt because it was destroyed as a result of the fire. In other words, by the erosion caused by the fire. So the same principle holds true in Journey's End and in any other place, whether it's a mobile home or whether it's a stick-built home. If your home is destroyed, whether it's by the fire itself or if it's rendered uninhabitable for other reasons associated with the fire, whether it's erosion, whether it's toxicity, whatever it is, as long as it is valid, and in this case, obviously it is since it was bulldozed, you can recover for the damage to that home.
Thanks, Jerry. I don't have any more questions via email or chat.
All right, so let's open it up. Who's got questions?
I have a quick question. I
Sure.
apologize if you might have already said something about it, but so as of right now, there's still no no even approximate like date of when we might start um, receiving anything.
No, I think based upon everything we've heard from the trustee, the goal is October or early November. And
Oh,
so that's what they're thinking.
uh-huh.
You know, a lot of it's going to depend upon the first month, so August, when they're running through the initial claims. Because again, the problem with this and what makes this so much harder than the other cases that we've dealt with is that there's only one side. There's
Mhm.
no other side who can say, no, that's too high. It's just we submit our documentation. The trustee looks at it and has to say, okay, well, I think that's too high. I think that's reasonable, that kind of thing. So
Mhm.
that's the problem. And so that's what they're going to be working on. And while they would love to be able to pay everybody everything they ask for, the problem is that's not going to be possible given the limited fund. And so they have to craft a system that's going to take that into account. So that's
Oh,
what they're doing now. Hopefully, it'll be ready for payments by October, November, but we'll have to see.
okay. Awesome. Thank you so much.
Sure thing.
I have a question, Jerry.
Sure.
And it's a little bit long.
Okay.
Have you recorded the town halls as we've gone along?
Yes, not every single one, but the majority of them would have been recorded. So if you'd like a copy, all you have to do is just email Chewy, and it's just chewy@slffirm.com,
Sure.
and he can send it to you.
So here's my concern.
Sure.
Not in last week. I listened to last week's town hall, but in the prior town hall, I asked you specifically about how the fees and the compensation would occur.
Mhm.
And my recollection was that I asked you based on $1 million thing, $1 million compensation for the economic or for the damages, and then the attorney's fees that were corresponded. And I asked, did the attorney's fees, any of the attorney's fees come out of that $1 million? And my understanding was you said no. But then I listened to the town hall last week. Okay, but here's my concern. You have sometimes referred to the award as an award, but I don't think it's been very clear to some of us that the award that you're referring to isn't the amount we get, it's the amount of what we would deserve to get plus the attorney's fees. And that then only in this very last town hall did I think many people understood how those attorney fees were going to work. And
Okay.
I think,
Go ahead.
and I went back and looked at my fee agreement,
Mhm.
and it's not very clear in the fee agreement either, because unless you know that those fees are going to be added together, and then 1/3 of that gross total amount is going to be taken. The fee agreement doesn't say anything about the attorney's fees are going to be included, and then it's going to be 1/4 of that total amount. And there's no way to, if you don't know that information, that you only recently, at least I only recently heard it. And it was different than what you specifically told me in the previous town hall. So
Well,
here's
so
my,
go ahead.
go ahead. So my
I was just going
concern
to say,
is
so let's, I'm
go ahead.
sorry. You go ahead, please. Go ahead.
I'll wait. You say what you want to say.
Okay, so what I was going to say is, first of all, I'm very sorry that it was not clear. In writing the fee agreement, we try to make it as clear as possible, which is why we said 1/3 of the gross amount that is recovered. But that said, I completely understand that it's confusing, and so why don't we do this? If Chewy can send you the prior town hall, just let him know what date you'd like. Please go through it and let me know what you're talking about, because I definitely don't want to mislead anyone. So please go
And
through it.
I don't think
Go ahead.
it was purposefully done necessarily, but I think that there's an opacity to how it has been explained. Maybe not intentionally so, but from a claimant's point of view, I think there's an opacity for it. And one of the things the person in the town hall asked you last time is, would you write out a specific numbers and explain it in your next communication? And I noticed this last communication didn't include that. I know you were dealing with other things, but all along, even before we voted, I think you've said many, many times, we want to make you whole. We're anticipating it's going to be 90 to at least 95% on the dollar. But I notice in my case, when I'm just guessing what my compensation is going to be, which of course I haven't really no idea yet, it sounds like it's going to turn out to be, if take some general claimant. If a claimant had been given $1 million for their losses, and then the 333 on top of that 333,333 for the attorney's fees component, and then 1/3 of that was that total amount was taken, that would be approximately 440,000. So you wouldn't be getting 90 to 95%, 90 to 95 cents on the dollar. You'd be getting less than that. And I just think the way it's written, it only once Mrs. Eck really pursued you last week did it actually become clear. And whether that was done, I know from your end, you're used to doing this. You're an attorney. You're used to writing these agreements. You're used to saying it in a certain way. But I really think it is, I actually think you told me something different in the previous town hall. Maybe mistakenly so, but it's just,
so go ahead.
it concerns me.
No, and I understand. And the last thing I want to do is mislead you or anyone else. So like I said, I think the best thing to do is please listen to the town hall, let me know, and then let's just have a conversation offline, and we can go through it. Because again, I want to make sure that you are made whole, and I don't want to misrepresent anything.
And I wasn't even just exclusively thinking of myself, but I could hear even in the last town hall, which you probably did too, that there's a lot of people who don't quite understand it.
Right.
And are wanting to understand it. Yeah. So anyway, thank you. Sorry, I don't mean to be hard on you. I just
no problem at all. I completely understand.
I just felt I needed to at least express that. So thank you.
Understood. No problem. Okay. Do we have any other questions?
Yeah. Hi, Jerry. This is Mark Goddard. I have a question. I think in regard to the last person's comment, I think it would help us all if you could, put up a theoretical amount. Suppose, for example, your total loss was $300,000. A third of that would be $100,000. Is that $100,000 added on top of the 300, and that's the claim that gets submitted, or not?
Okay, so let's break it down. So if your economic losses are 300,000, then here's how we've always done it in the past. If we agreed, and let's just assume that we're back in the Butte fire and we're negotiating with Quinn Emanuel, who is the attorney for PG&E. If we agreed that it was 300,000, those were your economic losses, then we'd add 50% for the attorney fees. So that would take it to 450. And then we would add an amount for non-economic damages, let's say 150,000. So that would take it to 600,000. So of that 600,000, our fee would be 1/3, which would be 200,000. You would be left with 400,000. So you would be made 100% whole for your economic losses, which were 300,000, and you would have another 100,000 for your non-economic losses. That's how the settlements worked in Butte. I certainly hope that's how they work here, but again, because we're in a different situation and it's the claims resolution procedures which the trustee ultimately makes, it's ultimately his determination.
So, Jerry, this is Joyce Mustin, Mark's wife. Are you telling me that we don't have an answer to this yet? That we don't know how these are going to be paid?
No, we absolutely, well, let me take it back. We don't know how they are going to do that particular aspect, the attorney fees, because again, the attorney fee portion of it, and by that I mean the amount that the trust has to pay, is not set in stone. The agreement that we had from both the San Diego fires and the Butte fires was just as I described. That's the way that we did it. That's called the Trotter formula. It was created by Justice Trotter, who's the trustee. And one of the reasons that we got him was that we wanted him to employ the Trotter formula here. But ultimately, the trustee is responsible for creating the claims resolution procedures, not any of the individuals. And so we'll have to see how he does that.
Okay.
That's very helpful. Thank you, Jerry.
Sure. All right, so what other questions do we have?
So ultimately, we will get an opportunity to contest whatever your statement's going to be of what we're going to recover, knowing then what our fee's going to be, right?
Right, exactly. So
Good.
obviously, if your economic damages were 200 and you ended up netting 150, then that's unacceptable. You haven't been made whole. On the other hand, if your economic damages are 200 and you ended up netting 250, now you've been made economically 100% whole, and you've recovered something on top of that for your emotional distress. So, my basic message is it really is too early, because we don't know what that process is going to be, and each of you are going to have the opportunity to test it out and to see if you're made 100% whole based upon what your damages are.
Mm.
Jerry, I have a question here about interest. It says that there has been some discussion about possible interest, which could be significant for those of us who have waited 5 years since the Butte fire. Can you explain that a little, please?
Unfortunately, it is unlikely to be significant, because it's not the kind of interest that you would get on, for example, a long-term T-bill or something like that. It is based upon the surplus rate that banks are able to borrow from the reserve, and it's typically less than 1%. So yes, you would get interest if the trustee decides to award interest, and certainly we think that he should. But unfortunately, it's going to be less than 1% a year. Now, if it's, let's say it's 1% a year, obviously that's 5% over 5 years. So it's certainly something. I mean, that's $50,000 on $1 million. But again, it's not like it's going to be 3% a year. So over 5 years, you get 15%. So again, I unfortunately, the rate that inverse condemnation interest is calculated is very different than the post-judgment interest rate. For example, there's a California statute that says that the post-judgment interest rate is 10%. Unfortunately, in the case law, that has not been applied to inverse condemnation. It's been much lower. And again, typically it's the California surplus rate.
I have a comment.
Sure.
Oh, okay. So I'm not sure if I'm on. This is Susan. I talked about the attorney fees in the last meeting, right at the end, and use the figures that people were presenting. And based on what I'm hearing now, the lady that was speaking earlier, I think there's still not a lot of clarity. Subsequent to the meeting, I sent you an email using the figures that we heard, the 1 million. And you replied to me very promptly, which I appreciated. So I think everyone would benefit by seeing those figures. So what they were was using an estimate of 1 million for economic damages. Rather than 33%, you used 50% for attorney fees and expenses,
Right.
and then an additional amount for non-economic. Well, and then you get the total sum and take a third, and that's the attorney fees. Well, if you start out with 50% for attorney fees and expenses, the client will come out okay. But campfire victims, you've told us the expenses are only going to be around 1%. So it's not going to be 50%.
No. No, that's the way we came up with the 50%. And again, this is something that Justice Trotter did. And again, the reason that I'm always reluctant to say 50% attorney fees is that we don't get 50% of your award. We get 1/3. It's the way that it's calculated in order to make it fair for the individuals. And so the Trotter formula, which is what we use and Justice Trotter created back in the 2007 fires, is that you take the economics, you put 50% on top of it, and then you put the non-economic damages on top of that, so that when all is said and done, the client keeps 100% of the economic losses plus 2/3 of the non-economic losses. That's how it comes out, and that's why we've always done it that way.
And I understand that's the best case scenario. But as you said in the email, the trust administrators might not go with the 50%. And if they go with a lesser percentage, and then attorney fees are calculated on the total sum, your attorney fees will be cutting into our share.
Are you there?
I'm still here.
Yeah, okay, go ahead.
Oh, you didn't hear what I said.
No.
Okay, all right. Well, what I said was, in the email reply you sent me, you said that the trust administrators may not go with the 50%. And so if they go with only 33%, and then that gets added on to our economic and non-economic, and then 1/3 is taken of that, the attorney fees will end up being more than the 33% of our economic damages.
Well, yeah, I mean, again, the attorney fees are 1/3 of the entire amount, and that's where I think the confusion comes in. And again, the best way to do it is to look at the end when you have your total award, to see whether or not you've obtained, when you have your net, the full amount plus something for having gone through it. And that's how you can test it when you come up with it.
I guess I've explained as best I can, but I don't know if the general client population out there really understands how this works, and I think it really would be good if you put that into an update letter.
Well, sure. It's just one of the problems we have is that when we raise this particular issue, it's caused a lot of confusion over the last couple of calls. And the concern I have in terms of doing a broad update letter is that we have, I think, 150 people on this call. If we were to send it out to 7,000 people, I think that it might create confusion where none exists now. And that's the concern that I have. I think the better solution, at least from my perspective, is when someone has concerns, to kind of deal with them on a one-on-one basis. I mean, we're doing it now, and it sounds like there's some understanding, although as the prior caller said, that there was some opacity, and she was concerned about it. So it just seems to me like if there's issues and if you're concerned, give me a call and we can walk through it. And I'll, I'm happy to go over it with as many times as we need to. But that's the reason why I'm not really inclined to send out a letter to everyone, because I don't want to create problems where none exist.
Yeah, Jerry, hi, this is Mark again. I guess my question would be, it's a follow-on to that, but I understand the Trotter rule or the Trotter guidance is outlined by you, and you said it's not clear yet when, the trustee will settle on what that guidance or that rule may be, whether it's the Trotter rule or modification of that. Do you have an idea when that will be cleared up?
Yeah, that should be part of the claims resolution procedures, which are being done now, and we hope to have them by the end of the month.
Okay, so we can expect, to have a formula that we could all understand by hopefully August 1st.
Hopefully, yeah.
Okay,
I would very much like to have that done by then.
Yep, thank you.
Sure.
Jerry, I have a few questions here submitted via chat.
Yeah.
One of them is, have the claim forms been developed yet? And will there be a number of forms since they are allowing us to file for each component of our total claim?
Yeah, no, there's one questionnaire that has a number of subparts. We have had drafts of it, but we're still working on it. The last one they sent out, we had some issues with. So we discussed this on our first meeting yesterday, and it looks like hopefully we're going to get the revised version by next Friday or the following Monday. And then once we get that, we'll fill that in, and that will be the submission.
Thank you. Another question here is, will the replacement cost of our homes be weighed against the fair market value at the time of the fire? The cost of rebuilding is probably, in most of our cases, well over the fair market value, unless the house was new when it burned down.
Yeah, that's a good question. It has to be reasonable. So, if the cost to replace was 5 times what the fair market value is, then that's probably not going to be determined to be reasonable. There have been cases that have approved up to 167% of the fair market value, but it really is a case-by-case basis. So, you look at what the diminution in value is, what the pre-fire fair market value was, and then the trustee has to make a decision as to whether or not a particular cost of repair is reasonable.
Thanks, Jerry. Another question just submitted is there any precedent from prior fire settlements as to the amount for non-economic damages? How are you going to be able to determine if the number is fair?
Yeah, typically a family would get, 150,000 under the Trotter formula. Could be less if it was, there's less people, or if there's, they had a lesser experience for some reason. Could be more if they were exposed to danger, that kind of thing. That's kind of the ballpark, the rule of thumb. I think that may be what they use here. On the other hand, they may use less. We just, we're not going to know until we have more information.
Okay. Jerry, can you please explain whether insurance coverage under ALE should also be exhausted at this point? We have not received all of that amount. How about any extended coverage for updated building requirements?
Yeah, so with ALE, if you're claiming ALE, then they will deduct the full amount. But if you're not claiming ALE, in other words, you're saying I was completely compensated by my insurance, then you don't have to worry about it, because they're only going to deduct the limits from those areas that you're actually claiming. In terms of structures and things like that, yes, they are going to deduct the full amount. So you want to make sure that you get those if you can. Now, it may be a situation where you're waiting to rebuild, but you have another, say, 150,000 or 200,000 available for the extended coverage. They are going to deduct that if you're making the claim that you want to build. So in other words, to use a simple example, let's say your cost to rebuild was 900,000 and you had 500,000 in insurance, which you received, but you had another 200,000 that was available if you actually rebuilt. Because you're claiming you're actually going to rebuild, in order to recover that 900,000, they're going to deduct the full 700,000, because as you rebuild, you'll get that extra 200,000. So that's the way that's going to work. What's next, Chewy?
That is the last question I received, Jerry.
All right. What questions do we have from the board?
I have another one.
Sure, go ahead.
So in previous meetings, you said that first come, first serve. So we all understand, correct, that Butte County Fire will be paid out before the Camp Fire does, because their fire happened prior to ours. So in order of first come, first serve, would Butte County be paid out first? So if we're looking at a payout like in October, November, December, we might actually look at something later than that because our payout would be later?
No, first come, first serve just means first submitted.
Okay.
So I think Butte, probably most Butte people will be paid out earlier because their claims are already worked up. So in all likelihood, they're going to be submitted as soon as it opens up because the workup's all been done. Whereas for a lot of camp people, understandably, they are not ready and don't have all their information in. But if, for example, there's a campfire case that's done and gets submitted on the first day, then it's going to be paid out toward the front.
But it's not going to be paid out be submitted until we get an opportunity to review what you're going to send us and tell us what our claim is, right?
No, typically we submit as soon as it's ready. If you want to review everything before it goes in, then just send us an email and we'll make a note in your file and send it to you.
Well, I guess I better do that then. Okay, thank you.
Sure thing. Okay, do we have any other questions?
Hey, Jerry.
Yeah.
Yeah, I have two questions. The
Okay.
first question is, we had to move into a place in Orland where we had to fix it up in order to live in it. That's a stipulation by the landlord. And I was going through the receipts and they faded, kind of. I mean, will we be reimbursed for that, or the landlord's not reimbursing us for that?
Yeah, I think you can do that as part of ALE. So in order to make it habitable, this is what you had to do. I think that's a legitimate ALE, alternate living expense claim.
Okay. And second question is, I lost my dentures and upper teeth leaving the fire. Should I be getting estimates or wait until the settlement? How should I go about that?
The best thing you can do is to go to, if you can go to the same dentist that made them and he or she can give you an estimate, that's the best. If you can't, then just go to any dentist who can do it. But the absolute best would be an estimate from the same dentist.
Yeah, he's retired now. He's from Pennsylvania.
Okay.
He's retired. Can't get a hold of him. My mom has tried, and
sure, that's fine. You can go to the same one, and if you need help finding somebody, just let the team know, and we can locate somebody for you. It probably would be in Sacramento. That's probably going to be the easiest place, but we can do that.
Okay, thank you very much.
Sure thing. Any other questions?
I don't have any, Jerry.
Okay. All right. So again, we'll probably get this in about 10 days or so, the questionnaire. As soon as we do, we'll forward it out so everybody can take a look at it. Probably won't be ready by next week, but I want to keep doing these in case people have questions. So let's do one next week. And if you have any questions in the interim, please either call or email us, and we can answer them. All right. Take care, everybody. Thank you.